Hi, I'm Jeff Abramson, your slightly disembodied voice here. We'll be starting in a couple of minutes. Great to see so many people joining in. Thank you. All right, fantastic. Thanks everybody for joining in. My name is Jeff Abramson. I'm the director of the Forum on the Arms Trade, which is a network of more than 150 people around the world who are concerned about the implications of the arms trade, security assistance, and weapons use. The Forum is now in its 10th year. It's a fiscally sponsored project of the Center for National Policy, and the Forum itself appreciates the support of the Rockefeller Brothers Fund and the Carnegie Corporation of New York. You won't see me for very long. I'm going to do a little bit about how we're going to use the Zoom today. I know we've all been on plenty of Zoom webinars in the past, but just to give you a feel for this one, and then a little bit of framing, then I'll turn it over to Roy. Um, we will ask you as an audience member to please put questions in the Q&A. You can see the Q&A that other people are asking. You can upvote the questions in the Q&A so we have a sense of what people are most interested in, and that will be what the panelists are looking at. We have also enabled the chat, which will enable everybody in the audience to talk with each other as long as we keep it respectful. I might also put some things and resources in the chat, but the chat is really not something that the panelists are going to be able to pay attention to as they're speaking and looking to the Q&A. So please do use the Q&A for that. It is possible for you to speak your question if you are called upon by Roy. It's all at Roy's discretion. So please do type your question in. But also, if you like, you can raise your hand, and at Roy's discretion, I will enable you to speak your question, which can make this a little bit more interactive. That's it in terms of sort of the technology. If you have questions about it, throw that in the chat and I can respond because I won't be in the panel itself. But as a bit of framing, this is the second of 3 events at the Forum on the Arms Trade Annual Conference. A few years ago, it's hard to remember, we were in the midst of the heart of the pandemic. It looked at that time like there might be an actual decline in the arms trade, a sort of decline in a militaristic approach to security and maybe a more focus on health or other issues. The United States withdrew from Afghanistan. It felt like there was a moment where sort of militarized approaches might be on the decline. Shortly thereafter, Russia invaded Ukraine, and now more recently, we see what's happening in Israel and Gaza. And I think you have seen a dramatic expansion of the arms trade as well as a production capability and weaponry. Is that the trend for the future? That sort of was a frame for our conference. And what are the counter trends? There are now many different lawsuits going on around the arms trade. And so the purpose of today's panel is really to look at that question. And I'm delighted to have Roy Ispister, the head of the arms trade unit, the arms unit at Safer World, which also is one of the lead organizations between the Arms Trade Litigation Monitor, which is a partner for this event, help us in this conversation. I'll thank in advance our panelists and turn it over to you, Roy. Thanks a bunch. I think Roy's looking.
Yep,
There you
there we
go.
go.
Got it.
Nope, we've got it. We're up. We're laughing. Okay, thanks very much, Jeff. And thanks to everybody for joining in on this. I think Jeff obviously started to introduce this, and for the session today, the title is "Are Legal and Human Rights Challenges at a Tipping Point in Changing the Arms Trade?" So that's what we're going to dive into in detail. I'll just say a little bit about who I am or who my organization is. Safer World, we're an independent international organization working to prevent violent conflict and build safer lives. We, as an organization, we've been working on the arms trade issues for close on 35 years now. I head up a very small unit, part of a Safer World called the Arms Unit. And one of our projects is the Arms Trade Litigation Monitor, which is in partnership with the Emergent Justice Collective and the International Commission of Jurists. And I'd ask, for those of you who are not familiar with the monitor, it'd be great if Jeff could just put that into the link into the chat. And I'd invite you to have a look at that, because it is trying to keep track of all the different challenges that have been taking place and that are taking place to the authorized international arms trade. And there's obviously a lot going on at the moment, so I would invite you to have a look at that. And when I say there's a lot going on at the moment, I mean, I compare that to, let's say, 10 years ago, when there was very, very little in the way of legal activity attempting to challenge government decision making on the arms trade. But then once we saw the escalation of Saudi-led activity in Yemen, that's when we started to see this picture change, and we saw a slew of national level legal challenges to government decisions. I do remember thinking at the time, is this the start of something bigger, something that will continue into the future, or to mix metaphors, is it just a wave that will crash and burn against the cliffs of government immovability? Well, now with Israel, we're seeing not only a resurgence in these national level legal challenges to the authorized trade, but there's a number of other related developments. So we're seeing cases appearing in front of international courts, related cases appearing in front of international courts, or cases that you would expect to have a bearing on the actual trade in arms. It's not just governments coming under pressure now, but also companies and even individuals, be they officials or politicians or company executives. The whole field of business and human rights due diligence has taken aim, as it were, a bit more on the defense sector as well, or the arms production sector. Divestment from arms companies, targeting of goods in transit. There's a lot going on, and there's also strategic litigation in other fields that are perhaps unrelated, but maybe they have lessons for this area. And also, I think it is interesting that, you know, as the international political environment is deteriorating, these other avenues are opening up, including these legal challenges, which I think is an interesting issue to consider. So anyway, what we're addressing today is how significant are these developments? Is it a flash in the pan? Is it another wave to crash and burn? Or is it something that is going to continue on into the future, and we'll see make more and more of a difference? We have three distinguished panelists to consider this question today. And the way that we're going to handle it is we're going to start with a bit of a look back. We will then bring things into the present day, and then get out the crystal ball and take a look at where we think things might be heading in future. But just one thing I want to say, because Jeff's told me I need to say this, and I might forget to do it at the end. There will be a very quick survey that will pop up when you exit at the end of the webinar, which you are invited to respond to. And there will be recommendations and follow-up resources will be emailed to you and available online in the coming days. I will try and remember to remind you of this at the end. We have 1.5 hours maximum. If we don't fill the time, we don't fill the time, but I think there's a lot to talk about. So let's move straight into the panelists. So we have Chloe Bailey, who is a senior legal advisor at ECCHR, which is an NGO based in Berlin that uses strategic litigation to hold states and non-state actors accountable for human rights abuses. She's been working on their business and human rights team for a couple of years now, and works on transnational legal interventions to advance corporate accountability in Europe. And she's currently involved in casework related to liability of European arms companies in the context of Yemen as part of their long-standing work on arms trade litigation. We also have Patrick Wilkin, who's got more than a decade of experience working on human rights issues for the Amnesty International's International Secretariat in London, most recently related to trade in arms and security equipment. And his work has covered arms transfers to Iraq, Yemen, Israel, occupied Palestinian territories, illegal arms brokering in the UK, trade in torture equipment, and human rights responsibilities in the arms industry. And our panel is rounded out by Michel Paradis. He's a human rights lawyer, national security law scholar. He's been involved in one high-profile cases around the globe, including some of the landmark cases to come out of Guantanamo Bay. He teaches courses on national security law, on international law, the Constitution, and the law of war. He's a fellow at the Center on National Security and the National Institute for Military Justice. So I think it's fair to say that Michel hasn't been as directly involved in some of this arms trade litigation as our other two panelists. So he's possibly bringing more of a kind of standing back perspective to the conversation. So I'm delighted to have these panelists with us today. And I just thought, just to kick things off, a question, maybe the first question to ask is to relate to the actual title of the seminar directly, and to ask, are we at a tipping point? Are legal and human rights challenges at this tipping point in changing the arms trade? And obviously, I think we'll be kind of returning to this in various ways over the course of the webinar. But I just think as an opening comment, I don't know, Patrick, would you like to kick us off?
Yeah, thanks, Roy, and thanks for this opportunity. I think it's a real opportune moment. As you say, we're at whether it's a tipping point or not, we're at a sort of crucial point, I think, in terms of both the arms trade, as Jeff said, and efforts to litigate. I think in terms of a tipping point, I mean, we've seen it's a very mixed bag, and I think the monitor is very good for representing that. There's been successful cases, in the UK, the Netherlands, Belgium. There's been less successful cases in France and Canada and elsewhere, and in Italy. But then I think in some ways, and this is one question that I have about the sort of the framing, is we don't want to be too binary about what success and failure means, because you can have narrow judicial failure but success in highlighting different issues. And the last thought I had on this was, the tipping point, I guess, is premised on a kind of progressive narrative of restricting unlawful transfers. I mean, you can also have kind of regressive moves, and we have seen that a bit. And in particularly, the one issue that strikes me is the court's deference to executive power, which comes up very strongly in many jurisdictions. And I think, obviously, I wouldn't say that we're on a tipping point downwards, but from a civil society perspective, we want to be careful to avoid sort of consolidation of more conservative readings in these litigations.
Thanks for that, Patrick. So Chloe, any kind of opening general thoughts on this?
Yeah, thanks, and thanks for the opportunity to speak about this really important issue, which is really a central pillar of our work in the business and human rights team at ECCHR. I would broadly agree with everything that Patrick has said. I think it is still really too soon to say whether it's a tipping point, and I think it's also, what does soon mean? Because I think if you look back at the litigation that we've been involved with regards to the Yemen conflict, that's kind of been ongoing since 2016, 2017, and we're yet to still really see what I would determine to be a tipping point when it comes to accountability efforts, especially legal accountability efforts. But as Patrick said, I think it's also often a mistake to look at it very narrowly through a legal perspective, because there is all of the advocacy that does accompany litigation, all of the other forms of pressure that can be used on governments, on corporations, that can also cumulatively sort of accompany litigation efforts. I agree, yeah, and I think we'll probably get into this in more detail in a bit later on. I agree that there are some maybe like indications of hope coming out over the past few months, but yeah, still a very challenging environment through which to pursue arms trade litigation.
Thank you, Chloe. And so Michelle, over to you as not as someone who's been a practitioner, perhaps, in some of the actual cases that have happened, but from that perhaps a more maybe academic perspective. What's your kind of your opening gambit, your starter for 10?
Yeah, I'll try and be, and probably because I'm not in the trenches litigating these cases, I'll be the most optimistic on the panel about the current movement, in both in terms of the number and variety of forms of litigation, to include some of the ones we're going to talk about today, has multiplied in ways that I think had we had this discussion 20 years ago would have seemed almost impossible, and that's including in jurisdictions that are typically quite hostile to arms control, including my own jurisdiction of the United States, where we have, constitutionalized firearms rights that have largely had the effect of immunizing not only arms traffickers, arms manufacturers from liability. And even there, we've begun to see cracks against some of our major firearms manufacturers. I think the other component that's only just beginning to be realized, but I think is going to pay a lot of dividends over the remaining decade, is the growing use of human rights due diligence and human rights due diligence obligations, particularly in Europe under the new directive, but also in the United States, where we have a much more convoluted system for this, but it does have teeth in terms of regulating corporate behavior, particularly public companies, where they end up being far more exposed for their activities than I think historically they've ever been. And so I will be the ray of sunshine on this panel and say that at the broad level, looking at the long sweep of this history, the ability to regulate the illicit arms trade, I think, has probably never been as robust, even though there are so many conflicts around the world, and many of which we'll obviously talk about today, where the arms trade is obviously alive and well.
Thanks for being our ray of sunshine, Michelle. God knows we need rays of sunshine at the moment. Okay, so let's now start to get down into the detail a bit more. And I want to look back to what was going on in around 2016 or so, and the situation with Saudi and others, including the UAE, being involved in Yemen. And this opening question certainly starts, I guess, with those practitioners, Chloe and Patrick. What led you or your organization to get involved in litigation? And also, what were your expectations and what were you trying to achieve when you began that process? So maybe, Chloe, if I can throw this to you.
Sure, yeah, and obviously I would preface this by the fact that I was not around at ECCHR in 2016, so I don't have on-the-ground information of the thinking at the time, but I can definitely say that it was specifically the role of European companies in supplying arms to the Saudi-led coalition, even despite, the reports of violations of IHL that sort of brought this to ECCHR's attention. And it's very much aligned with this narrative that we have at ECCHR around double standards and tackling double standards of European countries in particular. So that on one hand, they're sort of pursuing an agenda centered around human rights, but at the same time, they are committing, or in some cases, I guess, actively encouraging their arms companies that are located in their territories to sell arms to the parties to a conflict, like in Yemen, and sort of really thinking about the role of business in this. So at ECCHR and in the Business and Human Rights team, our focus is predominantly on corporate accountability. So we have focused on those big European arms companies that have been linked to specific instances of airstrikes, for example, in Yemen. The one other thing that I would say is really rooted in ECCHR's methodology of how we go about our cases is that we really focus on supporting those affected by human rights violations to access justice, and by sort of using transnational legal avenues. And all of our work with regards to Yemen has been done in pretty close partnership with the Yemeni NGO Muatana, we've been working with them on a number of different cases in a number of different jurisdictions. And so our whole strategy around what our goals are with the litigation, what are we really trying to achieve in terms of remedy, and how to link that to broader accountability efforts in conflict situations has really been informed by what Muatana have, what their strategy has been on this.
Okay. All right, thanks. And so for Patrick, then, from Amnesty's point of view, why did you start getting involved in the situation in Yemen from that legal perspective, and what were you hoping to achieve by through that involvement?
Yeah, I mean, I think I would just pull back a little bit to even before the Yemen conflict and say that, you know, Amnesty, along with Safe World and many other NGOs, civil society, had just come off a battle, sort of a decade-long battle to get the Arms Trade Treaty. And the Arms Trade Treaty came into force at the end of 2014. And as if on cue, about 10 weeks later, this very severe, and if anyone has forgotten the outset of that conflict, there was an incredibly severe bombardment that went through 2015. And so, as a, you know, for Amnesty, we were, you know, immediately documenting airstrikes on, you know, shops, on residential areas, bridges, you know, lots of civilian infrastructure. And, you know, as a result of that, and additionally, as the conflict progressed, there was a lot of diversion of weapons from the UAE into the south of Yemen, where we were also had a very strong human rights interest in the role of militias and the black sites where there was enforced disappearance and torture and other ill treatment. So we had very strong human rights interest in the Yemen conflict. And then I would say that at that time, you know, I would very much stress that this whole litigation has been a really collective effort involving many different NGOs. And in fact, you know, Amnesty, you know, has a definite stake in this in terms of the evidence it's providing of human rights violations and its role in the achievement of the Arms Trade Treaty. But our role in the actual litigation has generally been supporting others. And at that time, there was a lot of discussion between lots of different NGOs, you know, Muatana, ECCHR, GLAN, many other NGOs that were interested in this area. I think because of that timing that we'd achieved international law that we felt was immediately being violated. And so, I mean, in terms of we were involved in many different cases, but obviously the campaign against the arms trade judicial review in the UK was a key one, and we intervened alongside Human Rights Watch and others. And I thought that was a fascinating one. It still, for me, stands as a real landmark in this whole litigation landscape, and it was a bit of a David and Goliath effort that yielded results on appeal. And just the one last thing from that is that the one issue that we were very much involved with Human Rights Watch was the issue of the credibility of NGO evidence. And that was what we intervened on in the appeal, and in a very positive way, I think, in the sense that the first judge essentially dismissed the validity of NGO evidence, and the appeal judge conceded that it was actually, in some senses, more powerful than some of the government sources, in the sense that organizations like Amnesty International and Watano, of course, were directly on the ground and interviewing witnesses and analyzing strike sites.
Okay, thanks. And so, Michelle, the kind of, again, from that outsider perspective, from the academic perspective looking in, what did you make of that kind of initial, if you like, wave of cases that were being brought against the supply of arms to Saudi and UAE and coalition partners?
Yeah, I think they were incredibly effective in really doing two things that actually did have ripple effects in the United States, where the question of Saudi arms sales particularly is probably the most significant. One is that it creates the record, right? And I do think Patrick's point about NGO evidence is a really important and salient one, because often it's even in the best of circumstances, getting to verdicts, judgments in these cases that are favorable is incredible, or even unfavorable oftentimes, is actually an incredibly difficult task. And so a lot of the value that litigation can serve in the human rights context is by making a public record that's accessible and credible to a standard of proof that the news generally or newspapers generally are not going to necessarily enjoy. And so I just want to foot stomp that point that Patrick made about the particular value. And the echo of that, and I would sort of say the echo of that, then in places like the United States, which is the primary supplier of arms to the Saudi Arabia, and I think it was something like $64 billion a year all of a sudden during the war in Yemen, was that you began to develop political opposition to U.S. involvement in the war in Yemen in the Congress, and to some extent in a bipartisan way as well. This was during, from obviously much of the war and much of the arms sales were occurring between 2016 and 2020, 2016 and 2020, which is not coincidentally, the Donald Trump administration. And he took a very different view towards the traffic in arms, even going so far as, I think, to actually attempt to unsign the arms treaty. Which is not obviously something he can do, just to let you know, as a question of American law. That's not obviously effective. But regardless, there was obviously a very clear choice in the Trump administration to back Saudi Arabia and to sell almost as many arms as they could take off factory floors. And that created a bipartisan backlash in our own Congress that hasn't had, in a sense, the teeth, right? Very little of what Congress has actually, Congress has not cut off funding directly. But the fact that it has gotten very close several times, I think, had a chastening effect on the Biden administration's policy, where you had administration officials who were much more sensitive, not only to the sort of general issues dealing with the arms trade, but also just to the humanitarian crisis that was unfolding in Yemen. So that, the litigation, again, has, particularly in the human rights context, and it's often very discouraging, particularly for those people doing the litigation, such as our friends here and myself in many other circumstances. But that when you do take that longer perspective, the effects of litigation really have an ability to push the conversation in serious circles, right, where real power is being used, oftentimes with far more force than even an individual judgment from an individual national court or something like that. So I think it definitely had a salutary effect.
But to pick up on that a little bit, Michelle, so if I'm remembering correctly, there was certainly for most of that time, there was no specific cases being brought in the US, which was targeting US arms sales. So are you saying that that litigation in other jurisdictions still had an impact in the US, or is it more
Yes.
kind of litigation in other areas in the US kind of was.
No,
was
I actually mean even the foreign litigation, because if nothing else, it creates a record. It creates sort of opportunities for diplomatic friction by our close partners and allies, such as the United Kingdom, and it prevents, and oftentimes is the most important thing in the human rights context. It prevents a really difficult, hard to look at issue from falling off the agenda, when there are so many other sort of discrete political tasks that lawmakers are always going to be chasing down, particularly in an election year. So that's what I mean is, right. It's a broad front strategy, if you don't mind the military metaphor in this context, where what happens in foreign courts, so particularly foreign courts involving close U.S. allies, necessarily is going to ripple over in how policymakers in the United States have to approach these issues.
Really, that's really interesting, because a few of us were in a conversation last week talking about whether a legal challenge taking place in one jurisdiction would impact in a legal challenge taking place in another jurisdiction. But you're even talking even more broadly. Just you don't need that case in here for what's going on over there to actually make an impact. So that's really.
Yeah, and I
really
would say this, like, certainly as lawyers, we have a very lawyer-centric view of both the world and policymaking. And it's very easy to measure ourselves in our verdicts in courtrooms. But oftentimes, as I not to repeat myself, but oftentimes the value of litigation is just as much in keeping things on the agenda that need to be on the agenda, as well as Patrick said, just to reiterate, because I think it's creating a very durable and contestable public record that makes hiding the truth in a political context much more difficult.
Okay, thanks. I see Patrick, you've want to come in here.
Yeah, just very briefly. I also think there's a sort of the question of state practice, and during that whole period, at least smaller European states, some of them had stopped licensing arms to Saudi Arabia and UAE, and then you had the question of Germany and the restrictions on exports, and impossible to prove a negative, but you could. There was a lot of also media and public controversy I recall in Greece and Finland. There were sort of public controversies about weapons that had been seen in the field, and in France. So I mean, there was obviously pressures that might have been related to litigation, but also exposure of human rights violations and humanitarian law violations.
Okay, thanks. And maybe Chloe, just a question to you, because you have talked about how the ECCHR has this focus on corporate responsibility. Now, at the time of the Yemen cases, most of the attention was being paid to the behavior of governments. So how was the issue of corporate accountability featuring at the time, or was it featuring at the time?
Yeah, I would say that in the arms trade cases that we have been involved with, the sort of corporation hasn't always been the primary target. We've had to use other ways, other forms of legal challenges, including challenges to licenses, as sort of a way to get around the difficulties in pursuing corporate accountability through legal means. Because I think it should also be quite clear that corporate accountability litigation is not an easy thing. It's still very much an evolving field of law, even in Europe, now that we have sort of mandatory human rights due diligence legislation. I think it's interesting that Michelle sort of mentioned the EU CSDDD as something to discuss in this context. So it's almost felt a bit that even though we are a business and human rights team, sometimes in the arms trade, the business has kind of not been so much the center of the challenges. But I would say that, for example, in the communication that we filed to the ICC in 2019, ECCHR, along with a number of other different actors, filed a communication requesting the Office of the Prosecutor to investigate the potential criminal responsibility for complicity of company officials of European arms companies. So that I think is a pretty innovative legal argument. So it was both the corporate officials as well as government actors involved in the licensing processes, and that was both in Spain. That was for Spain, Germany, UK, France, and Italy. And then from that point, more recently in 2022, we filed a criminal complaint in France with the French NGO Sherpa and also Amnesty and Watana against 3 French arms companies, Dassault, Thales, and MBDA France, for aiding and abetting war crimes and crimes against humanity on the basis that they had continued to both transfer weapons to the Saudi-led coalition, but also provide maintenance services to the coalition, despite their knowledge, or their knowledge that they should have had, that the crimes committed by the coalition. And yeah, so that I think is, again, a pretty innovative legal argument that we've been using in France. Is still relatively early days with that complaint. And I think, you know, obviously the one thing that we should say about everything that we talk about here when it comes to legal challenges is the time that they take. So, you know, you may have filed a case back in 2017, for example. We filed a case in Italy, again with Watana, in relation to a remnant of a bomb that was found at a particular airstrike that could be connected to the arms company RWM Italia. And so this case was filed back in 2017, and it was only in 2023, so last year, that we got a decision, but unfortunately it was a negative decision from the prosecutor who dismissed the case. So, you know, there's like a 6-year period where it's under preliminary investigation by the prosecutor, you know, nothing's really moving. During that period, obviously, the conflict is ongoing in Yemen. So I think we should really think about, obviously, legal interventions are one tool, but they're not a particularly, they can't be used to really prompt a very urgent response, specifically when you're thinking about corporate accountability. Obviously, some of the challenges that are happening now with regards to Israel and trying to demand the suspension of export licenses, that can be a bit more of sort of an urgent legal response. But I think, yeah, this is one of the real sort of drawbacks when it comes to thinking about how to use litigation. But yeah, I would say that the role of corporations and the responsibility of corporations who continue to supply arms is definitely an area where there's still a way to go when it comes to really defining the scope of their accountability.
Thank you, Chloe. I've seen there's a question. We've got one question so far from Daniel Mack, which I think we'll come to. We won't address this now, but we will come to that, I think, a little bit later on. But just as a little reminder there, that the Q&A is available to you to use if you do have any questions for us. Maybe just, and we will, I think it's time probably to move on and look at what is going on now. But also, I suppose it would be nice if we all lived in the Netherlands, wouldn't it? Because they've just had a case which has been dealt with against the supply of components for F-35s, and which has been dealt with extremely quickly, and which I think has made a lot of people in a lot of other countries rather jealous. But there's a question to Michelle perhaps is the speed at which the wheels of justice move are intensely problematic if you've got people who are dying today, and you're bringing a case today. So how does this work longer term then, if you like? What can we expect the kind of cases that are happening today? Why bring these cases today, if you like, if you're not going to get a result anytime soon?
Well, sometimes you do get a result relatively quickly, and I'll point to one example in the international context that folks are probably actually quite familiar with, which is the Nicaragua case against Germany, where the people obviously are much more probably familiar with the South Africa genocide litigation against Israel, but another action was brought by Nicaragua against Germany, essentially challenging German arms exports to Israel, and was not, as a consequence, given the jurisdictional sort of quirkiness of the International Court of Justice and Germany's accession to it, was not actually limited to genocide claims. Instead, they could bring a much broader gamut of claims dealing with German essentially aiding, whether Germany was aiding and abetting violations of international humanitarian law and international human rights law. And ultimately, Nicaragua sought what are called provisional measures in the International Court of Justice, which in France would be, I think, like a l'estrange, or in the United States would be akin to an injunction, essentially preliminary relief. And that happened very fast. The International Court of Justice rules on that very fast. Ultimately, the complaint from Nicaragua was unsuccessful, but I would actually say the reasons it was unsuccessful were quite salutary for the ultimate objectives that it was potentially attempting to achieve, if those were beyond symbolic, because Germany's response to particularly the complaint or the claim for provisional measures emphasized that following the initiation of the Gaza war, Germany had been much more restrictive in its export of arms to Israel and to other parties potentially involved in the conflict. And that was ultimately the key for why the International Court of Justice denied the preliminary measures. It wasn't that Germany was off the hook. It wasn't an endorsement of the arms trade. What they basically held is that Germany is actually taking fairly scrupulous steps at this point in the litigation to ensure that its arms exports are not violating either the arms trade treaty or international humanitarian law more generally. And so that's a pretty immediate effect in an ongoing armed conflict where, did the litigation cause that? I think we can debate that as academics all day, but it's certainly Germany understood that it would have to answer for its conduct in real time, and that ultimately did achieve, again, in practical terms, the effect I think that any reasonable person would have wanted. Is Germany irresponsibly trafficking in arms to Israel? And Germany essentially said, we have all these constraints in place in order to ensure that we are not irresponsibly trafficking in arms to Israel. So that's one example. Another, though, and maybe taking the longer view, understanding how long these, and really almost every human rights case can take. Some colleagues of mine, just to give you a sense, have been litigating a case involving military contractors in Iraq for abuses in Abu Ghraib that only just went to trial about a month and a half or 2 months ago. They unfortunately had a hung jury, and so we're going to have to retry that case. But here we are, 20 years since the revelations at Abu Ghraib. But why did that case matter? Why do these sort of longer term, or why do these cases matter even when resolution or even decisions only happen in a very long period of time? Is that it's a kind of regulation for the future as well, where to the extent corporations in particular see themselves exposed to liability, exposed to very expensive litigation. Same thing with governments, I would say, but certainly with respect to corporations who have perpetual life and customers and brand awareness to be conscious of. They are going to regulate their behavior not simply in response to direct government regulation, but in light of the kind of liabilities they face. And that's why when you see really interesting creative litigation that gets around traditional obstacles to to accountability in really any human rights space, but I think in the arms trade, it's often been quite difficult. Those are to be lauded. One I'm happy to talk about more maybe in a little bit is just the litigation that Mexico as a nation state has brought against arms makers in the United States for essentially the proliferation of firearms to criminal gangs operating in Mexico. That litigation, had you told me about that litigation 10 years ago, I would have been like, wow, that's creative. But they've very recently had a lot of success. It's going to go to the Supreme Court. And well, we don't know if the Supreme Court will take it, but I bet they will. But that's, again, a very creative use of the law that if I'm an arms manufacturer in the United States producing firearms, I'm going to now have to regulate my behavior accordingly, even though I may not be involved in Mexico at all. I have to imagine myself sort of facing potential legal liability that particularly in the corporate context, again, in particular in the context of public corporations, creates shareholder risks and the risk of shareholder litigation if we're not actually mitigating what are fundamentally human rights risks, but at a practical level, also business risks for many of these companies as well.
Okay, thanks. Patrick?
Yeah, just a very brief intervention on the Nicaragua case, which I thought, it was, in terms of timing, a rapid turnaround. But like some of the other cases, even though it failed, it did force disclosure on Germany in the same way that the judicial review in the UK forced the disclosure of a lot of information about risk assessments in the UK. And it also did result in the court kind of reaffirming the obligations of states not to transfer weapons where there's risks of violations of both the Genocide Convention and the Geneva Conventions.
Okay, thanks. Yeah, I mean, I was a bit, not being familiar with the ICJ. I've been kind of shocked how quickly they've turned around things, even if it's not the case on its merits issue point to that point. But surprised by that. Also, just as an aside, I thought on the German case, I interpreted the German response as effectively saying the type of equipment that we have been sending to Israel is not of concern in the context of the war in Gaza, but the implication was there could have been other equipment that they would have sent that would have been a problem. Now, they didn't say this out loud, but I thought that was interesting that they've felt to structure their defense on that basis. But let's move into to Israel in a bit more detail and acknowledging this idea of the wheels of justice moving slowly and remembering the fact that there are these cases relating to Yemen that are still ongoing. So it's not as if that slate is wiped clean and we're starting again, or that it's only the Israel cases that are relevant at the moment. But interested, maybe start with you, Patrick, to get your sense of compare, maybe difficult to do perhaps, but kind of comparing the Saudi cases to the Israeli cases. We're a few more years on. We've got that background. Obviously, every context is different, but are there any things that you would pick out as being, here we go again, it's the same? What has changed?
Yeah, I mean, I think certainly there's been experience of litigation in this area. I think, as Chloe was saying before, with the Saudi, the Yemen conflict, there was a lot of experimentation and it was quite interesting. And there was there were lawyers that were approaching this kind of area of law for the first time. But now there is more experience in the field. I would also say that the case in some ways is much stronger because of the circumstances of the conflict. You have, the very confined area, the intense bombardment, the control of the borders, the use of heavy weapons in populated areas, the incriminating statements that were made by Israeli officials, the involvement of international courts, which sort of has lent gravitas to the arms issue. And I think, I mean, one gap, I suppose, is access to Gaza is difficult for evidentiary, collection of evidence, although we do have a field worker in Gaza, and we have documented 16 airstrikes and done similar sorts of work with looking at the blast site, retrieving remnants of Boeing manufactured munitions, for instance, and documenting unlawful strikes that have killed over 150 children. So it's not like there's no primary evidence. And yeah, so I think there's a lot of promising work in the area. You mentioned the Netherlands. I think it's sort of another interesting area. Again, there's been promising that Belgium has had various successful challenges, including on the transit question. And then there's the Denmark case, which is in some ways similar to the Netherlands challenge, which Amnesty Denmark has done some really incredibly interesting and innovative work, which I think shows that it's not just the litigation. I mean, they've done crowdfunding. They've done a lot of sort of consciousness raising with donors to the crowdfunding site. They've stimulated a lot of discussion and amongst concerned citizens. So there's perhaps a clearer case and a maturing kind of experience with litigation.
And what about what's the same, what's unchanged, what's kind of deja vu? Here we go again.
Deja vu. Here we go. Like, well, again, I guess coming back to the point I made at the very beginning, we still have this question of court deference to executive decision making, which we saw even in the Netherlands in the first instance, but we've seen in France and the UK, and that is I think a bit of an instinct that needs to be combated.
Yeah. Okay. And Michelle, from your perspective, then, do you see an evolution, a revolution, or just is it still very similar to what we've seen before?
It is an evolution now, but it's these things have a tendency to be exponential in their growth, right? Things evolve slowly over time, but as Patrick, just to kind of reiterate again, one of his points is as you see more and more expertise develop, that has a very salutary effect in litigation. For one thing, the lawyers themselves, get it better, and they're going to make fewer mistakes in advance. You also create precedents that may not have succeeded in one particular case, but that you can then use to reverse engineer the next stage of litigation. In addition, I think there is a growing, particularly because of the Arms Trade Treaty. I do really think that was a landmark in letting people believe and then forcing governments to accept that the arms trade, the illicit arms trade, is a problem that actually must be solved, and that has a broad political effect, obviously, in how governments must operate, but also in terms of even how courts and judges view these questions. Had you brought many cases involving sort of the irresponsible exportation of arms, prior to the treaty, right, you could make very good ethical arguments. But here, particularly depending on the jurisdiction, you can now say, look, there are binding international agreements that this kind of litigation is both supporting and fostering, so that you're not, particularly when you're dealing with these questions of, well, how much deference should the executive branch get, or, governmental officials more generally, you now have a rule to which the government has bound itself that is not discretionary. And I think there's just a civil society momentum and an intolerance and an understanding that that I certainly didn't see in the 1990s or in the early aughts, right, when dealing with conflicts in places like Sierra Leone or something like that, that there is a tight intersection between corporate activity, corporate choices, and the conflicts that we see around the world. So to the extent that this is now taken for granted, that I think does help, because it doesn't seem like you're doing something out of left field, right? Each precedent builds on itself and creates momentum that the next case and the next conflict can build upon, and then hopefully use more quickly. I know, because that's obviously one of the major issues, but nevertheless, it's an evolution, and evolution often accelerates once progress starts getting made.
Thanks. And so, Chloe, I mean, the same kind of question to you, I guess, but also when you talked about your focus of your organization on that corporate accountability side, by all means, don't limit yourself to just talking about that, but I'm curious to know if you're seeing much in that, on that side of things, that companies are feeling more pressure.
So I unfortunately don't have a direct line to companies to get a sense of whether they're feeling pressure. That would make my my life a lot easier, I think. I mean, I would say that at least from my knowledge, there hasn't yet been a case filed against arms company with respect to Israel. But that's not to say that, yeah, one isn't coming. It's not something that we're working on directly currently. ECCHR in another team, they did actually file a lawsuit in April with Palestinian human rights organizations against the German government to stop the export of weapons to Israel and to block the issuance of additional licenses. But that's yeah, not with a specific business and human rights lens. I would second what Patrick said about the sort of moving on from what has already been done before with Saudi Arabia, and sort of the really leveraging the coalitions that are already in place and the conversations that have already been happening among a lot of the groups that have been involved in litigation in relation to the Yemen. But what I've also seen as very much like an outsider perspective on current litigation efforts with regards to Israel is that there seems to have been even more of a collective mobilization in quite a short space of time, including within the same jurisdiction. So you've had multiple different complaints, sometimes using quite different legal arguments being filed. And I think that's actually quite an interesting development, because it also is a good way to test your different legal strategies. For example, I know in France, there's been a number of different coalitions that have filed different challenges to the French government around export licensing. And I think that's something that at least I'm not aware of that happening in the context of Yemen. And I would also sort of second the point about this issue of justiciability, and it's a real challenge. I think, especially in France, the sort of thinking that arms export licensing decisions are purely a political decision, and it affects the international relations of the country, and therefore it's not something for the courts to be involved with. I think that's a challenge that we have seen in the Yemen cases. It's coming up now with the current cases on Israel, and I think that's from our perspective at ECCHR, that's really important to sort of challenge this narrative that the arms trade is like a neutral business. It's not a neutral business, and the issuance of export licenses isn't like a solely political decision. It has massive implications on human rights, massive impacts on human rights. So yeah, even though I wish we were all like the Netherlands, I think that is not necessarily something that's going to that sort of decision isn't going to have really big ripple effects on some of the other large arms exporting countries in Europe, unfortunately.
Okay, thanks. Some of the things that are coming up in the answers, I can feel I could chase these down rabbit holes, which might not be that useful. So I've got to be wary of that. But maybe something on the business. Let's stick with you for the moment, Chloe. On the business and human rights due diligence side of things. I mean, I have been in the room when company executives have raised this as an issue that they need to be thinking about, if not particularly now, but that the direction of travel in terms of business and human rights is something that they might need to think about a bit more in future. But I'm curious as a non-lawyer, is if that kind of trend continues and there's kind of greater levels of accountability, are decisions that are being made now by companies and by company executives, are they at risk of being litigated in 5 years' time, 10 years' time? Is there that possibility for retrospective litigation, if you like? But also, from what I can see, there's this huge pushback from the arms sector in the CPDDD in Europe, and I can remember quite what all those letters stand for, but it's on due diligence, where there's been a carve out for the arms industry. In discussions around the Arms Trade Treaty, there's a strong pushback against bringing any kind of serious element of business and human rights due diligence into the frame. So how does that look for the future?
Yeah, so the CSDDD, the Corporate Sustainability Due Diligence Directive, unfortunately a mouthful. Yeah, I think this is something that we at ECCHR, we were really quite involved in a lot of advocacy at EU level to ensure that it did apply to sort of downstream activities, so that the sale aspect, and specifically relating that to the arms trade. It is really unfortunate that there has been this carve out for their export of arms. It seems like the EU has kind of adopted an interpretation that arms export controls are kind of synonymous with human rights due diligence, which is very much not the case. With regards to, what could this mean for companies? I mean, I think even though there isn't sort of the option under the CSDDD is kind of very out of reach now. I don't think that means that it's just a carte blanche for arms companies now. I think there are other legal strategies that can be used, even sort of leveraging the ideas of human rights due diligence in a slightly different way. I think we shouldn't forget about aiding and abetting liability, which is something obviously that we're pursuing in our case in France against 3 arms companies. But I do think that sometimes when one legal route is maybe made a bit more challenging, you have to be more creative. And I think that there are other interesting ways that we can think about corporate accountability. For example, what is, and something that Michelle said earlier with regards to sort of shareholders, what about the accountability of investors, of financial actors in this whole industry? That's not something that I'm aware of that has been sort of looked at in much detail, but that could potentially be, the next wave. And I think that's what we do as business and human rights lawyers. We look for the new opportunities through which we can try and navigate what is, as I said, a really challenging context for us to pursue cases.
Okay, thanks. I'll hear from, I think, Patrick, I see your hand up. So I think we'll, if you can talk to this, and then also we'll bring in Michelle. And at that point, I think we'll bring in if Daniel, if you could be ready to ask your question, we'll put your microphone on if that's all right, and you can ask the question with your voice. So Patrick.
Yeah, just very briefly on the corporate accountability piece. I totally agree with what Chloe was just saying, and I think it's a real disappointment, the EU directive, because when we started looking at this, which was 2019, and we did a report about corporate accountability in the defence industry, it was a new concept. There wasn't even though the Ruggie principles, the guiding principles, had been in circulation for a decade. It wasn't something that, and a lot of other sectors, industries had already ingested it in different ways and were starting to think in terms of human rights due diligence. It was totally foreign to the defence industry, and I think slowly, at least in Europe, the defence industry started to at least acknowledge that there was the guiding principles, and you had things like the UN Working Group on Business and Human Rights that also engaged, and others. And I think that the core point of that was that the companies have a responsibility that's independent of the state's willingness to abide by their human rights obligations, and that's completely undercut by the EU directive, which essentially agrees with the industry argument that if they can achieve a license, they have no further responsibility on what happens to their products and services.
Okay, thanks. And Michelle, from your perspective, and in the US, how do you see this developing?
Sure. So I would maybe take one point of disagreement, and I do think a lot of corporations are increasingly cognizant of these kinds of issues. I can't speak to the CSDDD. I think I got the acronym right that well, because I'm not a European lawyer, although my firm does a lot of cross-border representation. But I can tell you that certainly U.S. firms are very cognizant of human rights due diligence, and increasingly so. Now, how does that happen? Typically, it happens in situations of crisis, where a firm in one form or another gets called out for violating human rights in some part of the world, and then all of a sudden they realize that we need to have a much more robust program for you name the issue that unfortunately got them on the front of the newspaper. But increasingly in boardrooms and in the C-suites, corporations are understanding that it's not simply a function of evading future liability, but it's incredibly important also for brand management as well. Especially consumer-facing companies, but even non-consumer-facing companies that might contract with individual states or governments or other entities that are going to have their own standards, missions, you name it, pension funds, right? The kinds of issues we're talking about today have many tentacles into many directions. And so responsible corporations, and particularly public corporations, where the executives often have to make certifications under our securities laws, representing the accuracy of their assessment of their own business risks, are increasingly having to take human rights questions into that overall sort of assessment of what our business risks are. Is this going to be a situation where we could start losing clients based on reputational damage? Is this a situation where either our products or components to our products might not be able to be imported into the United States for violating various trade restrictions? So these can be very practical problems. And so human rights due diligence is, I would say, an area of a real growth inside certainly the United States corporate environment. And it's something where they hire lawyers as well as human rights consultants, like people who specialize in this kind of work, to implement reasonable plans that can stand up to lawyers and shareholder scrutiny, should bad things inevitably happen. And so that's perhaps one of the reasons why I'm going to be the ray of sunshine today. Is I do see, including from within boardrooms from major companies, right, Dow S&P 500 companies, a real cognizance of their responsibility for human rights due diligence, because there's a real strong business case for it as well.
But it's really nice to have a ray of sunshine coming out of the US at the moment as well. It's not just from anywhere, but from the US. But just a quick follow-up is how does that play out then for because often it's kind of where America leads, the other parts of the world will follow. But how does this play out for the interaction with subsidiaries or cross-border arrangements that involve American companies? Are those ripples flowing across borders already?
So they can. Again, this is not an area that is extremely well developed, but
Yeah.
when a corporation, particularly a multinational American corporation, begins to think about their due diligence obligations, a lot of that is, there are best practices, and one of the first things that essentially a due diligence analysis will do is something close to an audit, and that audit is going to have global reach because it has to. They have to see where all of the risks are likely to be. And so like across essentially the entire value chain, a corporation is going to be assessing its individual human rights risks. Again, not to repeat myself, but for a lot of the reasons I said. So if they have, a subsidiary in a foreign country that, or a partner in a foreign country that is engaging in, just to take it out of the arms context for a second, but engaging in forced labor, they may not have known that, but they can't bring any of those products or components back into the United States because the United States very strictly regulates forced labor in the importation of goods, just as one very concrete example. And so again, just thinking about how a corporation approaches this, it's with it's expensive, right? And they spend the money on it because they understand that there's value to be had, particularly in protecting their brand, but also in protecting their ability to operate. And then when executives have to sign off on, what are their meaningful business risks, they need to know whether or not they have, meaningful business risks that, could implicate them in violations of international law in many situations.
Okay, thanks. We'll go to Daniel now, but just one, I think, interesting point that's coming out of Europe at the moment with the war in Ukraine, the Russian invasion of Ukraine, is you now have arms manufacturing companies in the EU claiming that investing in them is actually supporting kind of ESG investment standards because protecting the security of the country, etc. So there's that kind of counterpoint coming through the politics there. But Daniel, if we can, I think it's up to Jeff to switch on your mic. But if I believe you have a question for us, and if so, by all means, ask the question. And if there's anyone in particular that you would like to address that to, then be my guest.
Thanks very much, Roy. Can you hear me?
Yep.
I believe so. Thanks very much. I'm Daniel Mack with Global Rights Compliance. And actually, I'd love to hear some thoughts on this from all three panelists. So I know, I think Patrick particularly might be interested in tackling this. And my question was regarding kind of looking forward opportunities to, let's say, disaggregate what we call the arms industry, in the sense of a lot of cases to date have looked at major conventional weapons producers and exporters, particularly explosive weapons and their use in violations of international humanitarian law. But what I'm wondering is, and I think Michelle spoke of the Mexico case against the gun industry in the US, and I think this maybe would be a little bit more in that framework. What the kind of the challenges and opportunities are going forward in terms of the small arms industry, the firearms industry, and ammunition, which of course, both in terms of due diligence and in terms of kind of economic political clout, is very different than a major conventional weapon producer. And the kind of violations that are done with its products are often within the realm of international human rights law rather than IHL per se. But I'm wondering if the panelists have thoughts of of what could be kind of future paths regarding the firearms industry internationally. So, you know, if there's other jurisdictions or courts that could consider a case like the Mexican case or similar ones. Thank you very much.
Okay, so I think Patrick, you were mentioned by name. So if you'd like to kick us off.
I can lead off. I mean, I think it's a really interesting question, and I agree that there does seem to be a lot of focus on, you know, particularly airstrikes, aircraft, large munitions, and a lot of the investigative work has been around, and some of the legal cases have been kind of hung off these very sort of visible and dramatic events, and you know, as you know, Daniel, there was huge focus on small arms many years ago. Maybe there's been less focus and inappropriately less focus. I mean, I think there has been cases in Belgium against FN Herstal related to small arms to Saudi Arabia. But again, I guess that's the IHL paradigm more than human rights. And I think, I mean, I agree. I'm not sure they've got an answer, and I'm really interested to hear what Michelle says. But I do agree that there's all the statistics about how, you know, the death and injury outside of armed conflict is vastly more than inside armed conflict, and there's this you know, the impact of small arms in places like Latin America and the Caribbean and so forth is massive and ongoing. And it should be an area that's ripe for litigation, and maybe there is a sort of bias towards these cases like Gaza that is international news and in the international courts.
You're muted, Roy.
Indeed, I was. Any thoughts for Michelle? Any thoughts on that issue?
Sure, I'd be happy to talk a little bit about it in the U.S. context, because I do think the Mexico case is again really fascinating, really clever lawyering, you know, threading through a couple of needles that the legal system in the United States puts out for any related, you know, anything affecting the sale of firearms. A couple options though that I think have been underexplored in thinking about, you know, even conflict-based arms trade and more in the aiding and abetting space would be the use of our anti-terrorism laws. In 2016, the United States Congress vastly expanded essentially the opportunity to bring civil actions under the federal terrorism laws in any situation in which a United States national has been injured. And those laws are written with exceptionally broad aiding and abetting and conspiracy liability provisions, and a definition of terrorism that basically means almost any organized violence. And so I think there has been some preliminary litigation under those laws. It's probably a little more traditional in the standard wheelhouse that you would expect, involving, you know, for example, ISIS or Al Qaeda or even Hamas attacks against that have affected U.S. nationals. But the breadth of those statutes, I think, has yet to be fully plumbed by litigants. Relatedly, some who followed the United States' sort of long saga with something called the Alien Tort Statute, which is a federal statute that provides civil remedies for violations of international law, probably know that the Supreme Court of the United States has largely sanded that law down to a nub over the past 10 years. However, what is often overlooked is that in 1996, Congress passed a statute called the Torture Victim Protection Act, which does not only essentially provide a civil action for torture, but also for extrajudicial killing. And the extrajudicial killing provision of that statute is actually quite broadly defined to also encompass what we would broadly think of as political violence. Then two other areas that I would sort of point up that I think are rife for litigation. One is just using various aspects of American trade law. I mentioned those before, but I do think particularly in dealing with corporations who in some way or another may be implicated in the unlawful arms trade, that trade law offers far more mechanisms for accountability than I think people really fully appreciate. And then finally, especially dealing with conflicts like the one in Ukraine. We also have extremely rigorous sanctions regimes in the United States that provide both civil and criminal liability to individuals, entities, and corporations that in one way or another violate American sanctions regimes. And those can be a little harder to use. Most of those laws require some form of government intervention or participation by the United States government. But the United States government, particularly in conflicts like Ukraine, has been quite willing to support. The current government, I should say, the Biden administration, has been much more willing to support actions taken against foreign registered foreign agents who in some way or another are implicated in violating the sanctions that are applicable to the Ukraine armed conflict. So there are a lot of very creative uses of the law, the existing federal laws that we have that I think are, will be interesting to see how they develop. But one of the last things I'll say is that in the Mexico case, what made that such an innovative use of the law is that they relied on state law, as some from outside the United States might not know, but the United States is actually like 50 small little European countries that each have their own domestic law. And in Mexico's in the case of the Mexico versus Smith and Wesson case, they essentially used forms of public nuisance law to hold arms manufacturers responsible for essentially improperly and willfully commercializing firearms and almost manufacturing them with an intent to redirect them for unlawful export into Mexico. And again, the Supreme Court might take up this case that's being litigated literally as we speak, and it's quite politically sensitive in the United States. I believe the Attorney General of Oklahoma recently called it an attack by Mexico on the sovereignty of the United States and our beloved gun manufacturers. But these are highly political cases. But at the end of the day, I think there's a lot of opportunity there to press issues that might, at the moment anyway, seem more hypothetical.
Thanks. I think I won't go to Chloe at this point because we're running low on time. We've got 8 or 9 minutes left. I'd like to give everyone a chance to say any kind of closing comments. So maybe we can go to another, just take one more question. But I just one thing that just occurs to me is I think we're being a bit naive if we think that governments are simply looking at all this litigated, this legal action and thinking, oh, that's interesting. Because I know in the UK there was talk of reducing the ability to bring legal challenges to government decisions. And I can't, surely in the US, if this Mexican case is successful, there's going to be a lot of creative lawyering going on then on the other side of how to ensure that this never happens again. So I think it's it's not like we're the only ones in the game. So I think we got time for the one last question. It's from Stephen Semler, and Stephen apparently is in a noisy place, and so he can't ask this question himself. So I'm just going to read it out, and if we can get some really quick responses because we are very short on time. So given the ICC's request for arrest warrants for Hamas and Israeli leaders, could the ICC also do the same for political officials who have knowingly enabled their crimes via political and material support? So, for example, could they seek arrest warrants for Biden and Blinken in the US and I guess in other politicians in other countries? If so, what would it take for the ICC to do that? And don't respond with a miracle or an act of God. So, Chloe, any quick thoughts on that one?
I'm afraid I'm no expert in the workings of the ICC. What I would say is from our experience with the communication to the ICC in the Yemen case, I think there's obviously like the legal aspect, but there's all of the other political aspects that factor into its decision making, and also the issue of from our specific experience, the issue of resources and also political momentum around certain issues, which I think from the perspective of Yemen is not so significant now. But yeah, as with regards to the legal aspects, perhaps my fellow panelists will have something to say.
Michelle, anything? And before we go to Patrick?
Sure. Well, mechanically, the prosecutor would have to essentially open an investigation and then ultimately present that to the pretrial chamber. I think under the circumstances, I think that's highly unlikely, not just for all the obvious political reasons, but also I don't know that it, for criminal jurisdiction to attach in the International Criminal Court, you actually have to show actual aiding and abetting liability. And that does not just mean a sort of general causal link to a particular violation of international law. You have to show an intent to violate international law. You'd have to show that I think the names mentioned were that President Biden and Antony Blinken were actually seeking to facilitate Israel's war crimes or Hamas's war crimes against Israel, et cetera. And I don't think we've seen any evidence of that. I understand this is a very contentious and violent conflict that raises the emotional temperature extremely high. But I do think, and this is me being a very stern lawyer and less of a ray of sunshine at the moment, I do think it's very important to remember what the bounds and limits of law are as well, right? That law is not policy, and even though it often does have a way of affecting and driving and even facilitating changes in policy. And so, casually accusing, the United States or any other sort of political administrations of war criminality by virtue of their participation or their permission or allowance of arms sales to a country, even if that country is engaging in war crimes, I think is something that we should just be much more careful about in the way we talk about it, because just as a practical matter, it could delegitimize the entire project of international human rights law and international humanitarian law if everything gets called a wolf. And B, I actually do think we have to remember that there's an important distinction between legal and values-based and political arguments. And we shouldn't try and use legal arguments to replace, values-based arguments to say that, if we don't like what our government is doing, because of the consequences that it's causing around the world, we should be able to make those arguments on their own terms and not feel that we must dress them up in every case in the language of war criminality. So that's all I would say about that.
Okay, thank you, Michelle. So we'll go to Patrick, but also Patrick, and with apologies to Balkrishna and to Alejandro, who've asked questions, but due to it's my own fault for time management, we're not going to get to those questions today. So apologies to you. But Patrick, any comments relating to that last question, and then maybe just to follow up with any kind of closing remarks that you'd like to make?
Yeah, no, I mean, I don't think I've got anything to really add on that question. I mean, I could make some closing remarks in response to one of the questions there, and this
Sure.
This question of armed groups and something I was going to say before, but it's obviously because we're talking about viable litigation. Really, we're only talking about Western states that are supplying arms into conflicts where there's international humanitarian law violations. And obviously, there's a much wider spectrum, and there's which we should be calling out, we should be naming and shaming, even if there's no prospects for litigation. And you have states like Iran, Russia, China that are supplying, not least Hamas and other Palestinian armed groups, but Sudan and Myanmar. There's a lot of these contexts that don't lend themselves to litigation, but that we should be naming and shaming.
Thanks, Patrick. And I think a really good point to finish on is that there are more conflicts in the world than in Ukraine and Gaza at the moment, and they do tend to take a lot of bandwidth, but there's a lot of hell going on in other places. Michelle, any final thoughts?
I'll just return to my sunny disposition after my last answer and say, no, everyone who works in the litigation of human rights counters daily struggles and obstacles and a court system that is almost designed for failure. And so bringing these cases is extremely stressful. I am fully aware, and very difficult. But the values that they establish are really long-term values that, it's very easy to get despairing in any given moment, particularly given all the violence and conflicts around the world. But as we look back, even 10 years, but certainly 20, 30, 40, 50 years, to how nation states and corporations have changed their behavior in response very often to litigation and the kind of information that gets brought out in litigation, and to the reputational risk that at least that corporations will face as a consequence of litigation. It's, you know, a reason to be optimistic and even hopeful that the causes for which all these individuals on this panel have been fighting so strenuously for are noble ones, and that there will be success, but it takes a long time and it requires a lot of patience.
Thank you, Michelle. And no offense to Chloe, but we should probably have had you speak last to go out on such an optimistic note. But Chloe, any closing words from you?
Well, I feel like I need to change now to be more optimistic than I was going to be. No, I was just reflecting, you know, say if we were to have a repeat of this panel in 10 years' time, I really hope, and yeah, I'm optimistic that there will be some improvements, especially when it comes to corporate accountability. I feel like we're just getting to the point in some of our cases where there's maybe some encouraging signals that we may be moving forward. But as we've repeated multiple different times on this panel already, it takes a long time, and it doesn't move fast enough for the individuals that are directly affected by conflict. And I think that's really what we've got to think about at the end of the day. And I think it's that's sometimes really easy to forget when you're sort of developing litigation strategies in Western countries, which can often seem very removed from the sort of daily struggles and daily horrors that many people in conflict situations face. So yeah, that's sorry, too pessimistic. But yeah, I'm encouraged by what Michelle in particular has mentioned today, with businesses maybe taking this a bit more seriously. I would say the proof will be in the pudding over the next few years.
Well, actually, I think that was a very good point to finish on, Chloe, is to remember the people who are actually affected by this and on whose behalf this activity is taking place. They should never be forgotten. And so with that, that's it from us. We were supposed to take possibly to get into a more explicitly moving forward phase on the conversation, but I think that did kind of feed through the conversation overall, and clearly there was a lot to discuss, and we could have gone on longer. So I'd like to thank everyone for sticking with us. I hope you found that interesting. I certainly did, and a big vote of thanks to our panelists. Thanks also to Forum on the Arms Trade and Jeff for arranging this whole thing. Also, thanks I meant to give at the beginning, and that is for, on behalf of the Arms Trade Litigation Monitor, to thank Joseph Rowntree Charitable Trust, who provide the funding for us to be able to keep that monitor going. I think there's also, I am remembering to tell you that there is a survey coming when you exit. It's Jeff assures me it's very short, and he'd appreciate it if you could fill that in. And there will be something coming, I think, down the line in the next few days, recommendations, follow-up resources, etc., be sent to you on email, and will be available online. I think that's everything from me. So thanks very much, Jeff. I don't know if you've got any closing remarks.
Nope. Thanks so much, everybody. Thanks, panelists, and thanks for attending.
Cheers, folks. Missing you already.